It's not an express constitutional requirement, but I would like to get the views of what this means for our country's constitution. Joining us is Mr. Dan Mafora, regular guest of ours on eNCA. Very grateful for his time from the Council for the Advancement of the South African Constitution. Dan, good afternoon to you, and thank you again, as always, for your time. By not having John Hlophe in this process, the fact that this was raised as a concern, does this advance our Constitution? Let me start with the very title of your organization.
Good afternoon. I think what we're seeing is the Constitution being stress tested. And the question is whether our institutions are strong enough to, withhold the kind of pressures that are being placed on them and on the Constitution. And so far, we've seen that the JSC and the courts have resisted this attempt to kind of disregard what requirements the Constitution places on the kind of people who can sit on the JSC.
But it certainly brought to the fore a number of questions, Dan, which I'd like to go through. One of those is if John Hlophe, in the case as what we've seen now, is not considered to be part of the JSC because of being an impeached judge, because of questionable behavior when he was a judge, it also brings to the question how he was allowed to become an MP if an MP is supposed to be above reproach, above not above the law, but above any misgrievance of the law. How was he even allowed to be made an MP? People are asking that question.